We're at Scarinci Hollenbeck, and I'm sitting with Donald Pepe, a partner who handles complex land use and real estate transactional matter for a number of high-profile clients at the firm. Good morning, Donald.
Well, thank you for that introduction, Nicole.
You're welcome. So we were just chit-chatting a little bit about current trends in the real estate market, and I thought it was pretty interesting. So would you like to elaborate a little bit about that?
Yeah, I don't think it would be too much of a stretch to suggest that the commercial real estate market's been in a great deal of flux since 2008. During this period of time, a lot of substantial developers and operators have gone out of business. Obviously, there's a lot of vacancies. We've seen, staple operators like Blockbuster Video, a lot of electronics suppliers, a lot of the mid-box suppliers, simply closing up and going dark, which is, had a substantial impact. Even the operators that are going strong today are looking to downsize their space, and it's a phenomenon that's called, clicks to bricks. A lot of these operators are finding that they're basically serving as a showroom for internet operators, where people come and look at products and then go home and order it on the internet. The result of that is they don't feel, these operators don't feel that they need the same amount of space anymore. Take a staple, very strong operator like Walmart stores. Their prototype 6 years ago was a 220,000 square foot store. That's gone down to 159, progressively down to 129, and now they're opening up a lot of 98,000 square foot and smaller stores. And I think that's a trend that we're seeing across the boards.
I find that shocking because it's such a change in the way we're used to seeing our economy and such a change in the way that people are doing business. So do you have advice for clients who might be facing this situation?
Well, I think it could potentially have a significant impact on smaller operators. When you look at a shopping center, you might be inclined to presume that the big stores, the mid-boxes, the pet food stores, the staples, that they're the ones who are actually desirable to a landlord. Well, they are, and anchor's important. But per square foot, the amount of rent that they're paying is substantially below what you'll see your average nail salon or pizzeria paying. Those nail salons, those pizzerias, they are the bread and butter of these large shopping center operators. More and more, it's difficult to get new business loans to open up those small mom and pop type operations. And, as a result of that, regular market forces, there are a few people looking to enter the market. They're a very desirable tenant for substantial shopping center operators. And as a result, those tenants have a lot more pull than they might otherwise have had years ago in negotiating a lease agreement. What's important for them, and briefly I'll talk about this one aspect, is to try and push for subordination, non-disturbance, and attornment agreement. I'll explain in a minute what that is.
Yes, please.
But traditionally, a smaller operator would not have the leverage to insist upon this type of agreement. The agreement is basically an understanding between the shopping center owner's lender, the tenant, and the shopping center owner. And in essence, it says if you foreclose on the shopping center owner, you'll become my landlord and you'll abide by the existing terms of the lease. So you are a small operator, you've put in years of establishing goodwill at a particular location, and through no fault of your own, the owner of the shopping center that you've been operating in fails to make their balloon payment. The lender comes in and forecloses on that mortgage. Without having this SNDA, the subordination agreement in place, your lease is wiped out. You're just left to fate then. Maybe your lease is something that the lender would want to maintain. Maybe it's not. If you've been there for a long time and you're not paying market rent anymore because you've had the benefit of having negotiated a deal at a better time, that lender will come in and wipe you right out. If the shopping center is not performing well overall, that lender might look to come in and wipe everybody out and just redesign the whole shopping center. Without this SNDA agreement, you don't have a leg to stand on.
So is it just the tenants who have to be concerned about this and who have to adjust their thinking to confront new market challenges?
No, I mean, obviously it's across the board. To landlords, to substantial shopping center owners and operators, traditionally, one of the items that a big box or a mid-box retailer would look to have in their lease agreement is an understanding of what other uses can be put into the shopping center. Typically, and I've seen hundreds of these over the years, a tenant will look to restrict things like retail office, general office. They will look to restrict health clubs, gyms, schools, anything that generates a lot of long-term parking usage. And traditionally, landlords were willing to grant those exclusives or those use restrictions. Now, today, what we're finding is that a lot of the most successful retail shopping center owners were the ones that did not grant those use exclusives and restrictions. And the reason for that is that when a Staples comes to a shopping center owner and says, listen, I don't need 65, 70,000 square feet anymore. If I'm going to stay in this shopping center, I want to drop it down to 40,000 square feet. What you basically have is they're willing to stay in the front of the box, so you wind up with an empty back of the box. What do you do with that? Well, that's the perfect place to put the gymboree. That's the perfect place to put the walk-in medical. That's the perfect place to put the H&R Block, because they don't need the frontage. They don't need the exposure to drive their customers to their location. And if a landlord 15 years previously had granted to Walmart a restriction that prohibited schools, well, there goes the Barbizon salon. There goes the the hair and makeup school. So it is important for commercial landlords to pay particular attention so that they can maximize their flexibility as to how they're going to utilize their space going forward.
That's really great advice. So do you have any parting advice?
Well, it's probably good advice in any aspect when you're negotiating with somebody for anything. Make sure you have enough time. You don't want to be rushed into making a decision. You want to be able to weigh the variables and weigh the information that you're getting. Try and always look at 2 or 3 sites in parallel, because it gives you a lot more leverage when you're negotiating for a particular site. You may love it. Try not to let that out. Get yourself some help. Commercial landlords, they have legal teams. They have outside counsel. You need it as well. Your broker can be very helpful, but ultimately your broker's working for a commission and your broker's working for the landlord. So get yourself a good representation. It can make it can make or break you 10 years down the road in ways that you can't even anticipate now.
That's great. Thank you. So there you have it. For more information, make sure to check out Scarinci Hollenbeck's website and their business law blog, where Donald is a regular contributor. I'm Nicol Moeller, and thanks for watching.